Good morning, everybody.
Good
morning. We are going to start. We probably have some other people coming in late, but that's their problem. My name is Vicki Iozia. I'm proud to be the first president of the League of Women Voters of Citrus County, and this is a wonderful opportunity for me to introduce our speaker today. You know, I watch people, and being the president of the League of Women Voters here is such a wonderful thing to me because I get to learn so much. And I watch most people who either don't care or don't want to get involved in what's going on. And that kind of frustrates me. But then there are people who not only care, but get involved and stay involved and work year after year to change things. People and personalities make a huge difference. I get the opportunity this morning to introduce one of my personal heroes. I have been watching Cecile on Zoom for years, all of the things that she's done, and to get to meet her in person today is really cool. If you read the next newsletter, I've already written my column, and it's about not giving up. There are many people, they're attacking us from so many different angles, and they want us to just go into a fetal position and give up. And I know, because I've seen Cecile, even during the time when you were ill, you never get up. You never give up. And I admire that, and I'm going to copy your behavior. I will not give up either. So please, I give you Cecile Scoon, Esquire.
That was very kind. Thank you so much.
That was very true.
Good morning, everybody.
Good morning.
I'll just adjust a little bit. Okay, I'm benched. That's right. Well, it's a pleasure to be here and an honor. I'm glad you're recording it so it can be available to others to make it their opportunity. So the league has been involved with this issue for a long time. It's something that some of our league members were working on long before the state league got involved. And there was a little hesitancy for the state league to get involved. And this is maybe 8 or 9 years ago, but we had tremendous volunteers who were right in there working directly with Desmond Meade. One name comes to mind, Mary Jane Rains. Just an amazing person. She would drive up the highways and get signed petitions and get new ones from Desmond. They have a great story. And over time, people were asking the state leadership, hey, let's get involved. And eventually, they did. And I was one of the advocates over the years to get involved. And of course, since I had come onto the state board, since I've been advocating for it, they're like, you get in charge of it. So this is something that's been close to me and exciting and very amazing. And for a time, it was on the lips of everybody. It was the dominant issue at the legislature, at the Capitol. And during the time when they were trying to, once it got passed, even before, there was tremendous connection and community involvement with a lot of different groups of people. I mean, it was something that was really, beautiful to see how people connected to the issue. And I myself made it a point to talk to as many people about it as possible. And one thing I learned, and I shared this yesterday, is I live in a very conservative area in North Florida. We call it LA, Lower Alabama. And there are a lot of people who wear their symbol of their background on their shirts or their hat, Confederate flags and things like that. And they feel like, this is my history. I'm not ashamed of it. I get that, really. But still, to a person who looks like me, an African American, don't talk to me, we're not going to connect. But I said, in this endeavor, I spoke to everybody the same. I don't care if they were chewing tobacco and had their shirt on their hat, or someone that I might, assume that we would connect. And I saw almost no difference in the willingness to sign the petition. Seemed like everybody understood we've all made mistakes. We've all done things that we're later on not proud of. And if we were just bound from that one or whatever series of mistakes and never could change and have an opportunity, what a waste that would be. And so that was really pretty amazing that people from many walks of life saw the need to it. So it was a great cause. And it was very empowering to have those communications. And at that point, I was traveling all over the state with the local leagues, and we would always set up a table, or be it the library or the Walmart or something. And you do see all the citizens of different backgrounds. So I wanted to share that. And even though it's not where we want it to be today, that underlying energy and support for this concept is still out there. And and during that legislative session, when DeSantis was saying, we want implementing legislation, we knew that was a bad sign. And we ended up with a Florida statute 98.105, I believe is the site, that says that you have to pay all of your fines and fees that was included in the Amendment 4. Now, that's not what the main proponents of Amendment 4 thought, but that was laid on to us. And the difficulty is, in one aspect, the records were not kept properly. The financial aspect of sentencing was something that was not taken seriously, because this community of people often had tremendous difficulty getting work, coming out with a felony and whatever their charge was. So they were barely making it. So it wasn't even in the system the records to be well kept. In some courts, it was kept in the courthouse, and then some in the probation office, and then probation office moved, and then all the hurricanes and floods and mold. I mean, this stuff was not kept. So we found out, and it was established, many of the records you really couldn't get back 30, 40 years. Receipts of people sometimes who paid, or the family members had started paying, and what was the amount anyway? It was just kind of crazy. But even in that fight, I was a representative of this issue, and I testified many, many times before the legislature. And there was a time, just to show you how the league can make a difference, there was a time when one of the legislators, who was very, very antagonistic to Amendment 4, and was always coming up with additional procedures that had to be done. Well, he had an amendment, and he wanted it to be that people had to pay all the interest. Yeah. So here were 30, 40-year-old things, and there might have been a $500 fine, but by the time they were looking at it, during the time we were doing the testimony, that $500 fine might be a $5,000 fine, right? And there were many other people, groups, Southern Poverty Law Center, ACLU, a lot of voting groups that were there testifying against things. But this is how many of the other groups work. See, this is an example. They have backup back at the main office, whether it's New York or it's a regional office. So many of the lobbyists for Amendment 4, they would get their detailed instructions from the top, and then they would voice it very well at the meetings. But the league didn't have that. The league was just a few of us who were very involved. In my background as a lawyer, I was the point person. So that day when that amendment came out of the blue, I spoke to the other people, and they're like, well, are people up, haven't talked to us about this? And I'm like, well, it's up to me. So I immediately pointed out that what was written was, again, it would be a snowball thing. And the legislator said, "Oh, I didn't mean that. That's not what I intended." I said, "Well, sir, that's what you wrote." He was so annoyed and embarrassed. He took it out the next day. And the rule that's actually in the Division of Elections, they have basic rules and guidelines, and it was placed into the statute. It should really be called the League of Women Voters Rule. Yes, it was that willingness to speak up and just not be silent that got it pulled out. In this rule, we're going to cover a little bit of it, but it's the one that says you only have to pay what was written at the first time, at the day of sentencing. It's called the Four Corners Rule. And that has made it possible for many people to be able to vote. And that was directly from the league. Testimony day one, rolled out day two, with, sort of grumbling by the legislator who had put it in. But anyway, those are the kinds of things that people don't really know. That, of course, the league was very involved, very much. I think we were the largest volunteer organization pushing for Amendment 4. Everybody else pretty much, again, you get out there, they're okay. That doesn't mean their heart is not in it. But there's something to be said for people to spend hours on things, travel, give up their weekends, spend the day at the library, because you care. Because it's that foundational to your sense of well-being that others have the opportunity. And that's something when the league spoke at that time, that was just like a halo around our heads. Because everybody else in the room, and I've been in a lot of rooms during the fight over all of this, with brilliant lawyers and people and activists and organizers from, every progressive organization you can think of, and everybody in the room was staying except the league. And we were still at the forefront, and it was an amazing thing to see. So that's a little bit of my viewpoint of being part of that pathway. And this, what we're going to cover in now is, some of the techniques that we developed to try to make, pull it together. Okay, so without further ado. There we are. Okay.
I think it's working from my mouse.
You're doing it.
I just did it, yes. Okay.
Okay, so what are the work there?
Yeah.
Do you want to just do it?
Sure.
Okay. Thank you. All right, so we're league members, so we know our history, but we're often doing this presentation. Well, we actually have guests, and we not be league members. We want them to know that, we've been around over 100 years. We are the descendants of the suffragettes and just took up the cause. And when women got the right to vote, they had no history of voting. So we assume, because now we have this great right, but you don't know, we did it for ourselves. And then we saw importance for the community. And we do accept that. That's a picture of us, probably 2018 or 2019, and at the state capitol, our lobby days. That's right. Many of us know that the whole idea of felony disenfranchisement stems from preventing newly freed former enslaved people from voting. And so and we know that because they actually said that. Black and white legislative history. That was in their words, and it was their conscious effort. And in addition, they felonized things that were misdemeanors. Pulling an apple from a tree, fishing in the pond. These were things that were allowed during slavery to augment people's nutrition. But all of a sudden, after the Declaration, that became a felony, and it was just a big old trap. So they wanted to label as many of the African American new citizens with the right to vote. They wanted to knock them out this way. And it's kind of eerie how we see the effort to knock out voters again. This was right on paper. What we actually learned though, with dealing with Florida Rights Restoration Coalition and Desmond Meade, they spent a lot of money on polls and surveys. And for the state of Florida, I'm sharing this with you, but we did not put that first when we were advocating, because we wanted it to be something that a lot of Southerners would not immediately go, well, that's for Black people. You know what I mean? So we talked about the universality of everybody getting a second chance. That just really flew. And people, like I said, that was something that every community and most of the major religions have that in their training, that of stories of people given second chances and how important that was. So we did that. Next one. So I mentioned earlier that the whole legislative effort and the battle back and forth, and the statute that was done. And yes, this is the Jim Crow we were talking about. Next slide.
What it's doing, there we go.
Okay, these are just some stats to let you know how many people have lost their vote, the right to vote because of the statute. And in Florida, it turned out that 1.7 million Floridians, about 1/10 of the voting population, are disenfranchised. And that's a whole world of people. Next slide. And for African American men, it was estimated to be 1 in 4 to 1 in 5. And most African Americans have a close family member, myself included, that has a felony. So this is something we live with. Generally speaking, it's not over there. It's something we deal with in our lives. And we actually have states, the wider the state, they never had to do that because they didn't have a class of people they wanted to shut down that way. So the further north you go and the more the hinterlands, they never had felony disenfranchisement. And as you come down, they have finish your imprisonment. They have some where they vote from prison. Mm-hmm. So again, it really tracked race. The clemency process that we had before which is the same one we still have now, extremely cumbersome. And very few hearings a year, and they would do 20 hearings. I mean, it was a joke. People were lined up for years. So it really wasn't working. Except Charlie Crist, even when he was a Republican, his heart was open to people having new chances. And you could see the numbers, 150,000. And before him, a reasonable amount, 75,000, Jeb Bush did. And then, Rick Scott, it just went down to 3,000. And under DeSantis, I don't even know his numbers, but he's had very few hearings, sees very few, and says no to most of them. He told Desmond Meade no at one point, I think. And Desmond now has his voting rights back, but he's very, DeSantis is very strict on this. So we talked a little bit about Desmond Meade and the Florida Rights Restoration Coalition. Many of you are familiar with him. And working with a lot of support groups, and the league was a major support system for, you got the petition. And we voted. It was the highest percentage to get it on the ballot, I think, in recent history. Next slide. And I think the effort to raise the cutoff to 60%, instead of in most states at 50%, it was 50% in Florida, was in part to shut down citizen voices. And now, unfortunately, this citizens initiative process has been attacked, and the league has been litigating that, not even related to Amendment 4, but they just don't want to hear from us. They don't want that pathway. Every state does not have a citizen initiative process. It's rare. It's really rare, and it's a prize. And that's something we need to work on. So there's the amendment. two exceptions. If you were convicted of murder or sexual felony, no. You have to go the clemency route. Right, 64.5%. Okay. So we have to do the pay the fines fees, and I talked earlier about the difficulty of even establishing what is the fines and fees. The statute, the legislative bill was Senate Bill 7066. Next slide. And during that legislative session, there was another statute that was a leading statute. And that one said that the one that was leading till the very last day of legislative, the day that nobody can testify when they're on the floor, they did a switch around. Because prior to that, the leading statute said if there was a civil lien, you could vote. Out of the 1.7, about 800,000 citizens have civil liens. The judge, they would do this, they would convert your criminal fines into a civil lien. So it didn't wipe it away, but you were able to then say, that you completed your sentence, that you didn't owe anything, like for applications to get into apartments or jobs. It was a safety valve. If the person ended up, winning the lottery, they'd have to pay the money back. But you really have to have a lawyer trained to do it, and you have to have the person with felony convictions be aware that there's a path. So there was that huge challenge to get the word out to different groups. And the league created a program where not only did we train the lawyers, we have 4 or 5 experienced lawyers, and people could ask us questions, right? And so we had that additional, we also we had a call-in line, can I vote? And people would call in and ask for help, and then we would do referrals. Oh, that's not what I want to do. That's what it says receipt. So that's clear. It makes somebody get down. Oh, there it is. There. We're back. Okay. So if you have in the statute, it says we can go back. Go back. To the right place. That's what where the word was there. So there it says in the statute, if you have a felony conviction in another state, that would be a bar in our state, you can't vote, even if you could vote in the other state. If you are allowed to vote in the other state, and it's not specifically something that we outlaw, like a felony sex offense or murder, you can vote in our state, which is why President Trump can vote. So quite a few people got the right to vote because they had completed everything, and there were some people who had no fines. The judge just said, you're just going to do straight prison time, or, that's what they did. And a lot of judges understood, these people are not going to pay any of this money back. I'm not even going to put it on the paper, right? So there's a look of the states that have the most stringent, you cannot vote again. And you see a lot of it's in the South, so the Southeast. Yeah. And these are the ones that show again, who right now still has some of the toughest laws. In Florida's got one of the darkest hues. Texas too. We had a lot of litigation, went all the way up and everything. Interestingly, in the litigation, all the state experts admitted, Maria, or last name just flew out of my head, but she was in charge of all the lawyers for the Division of Elections. She was an expert witness, And she admitted, as every single state person admitted, the records were in disarray. We can't find them. You know what they said? They had 27 lawyers at the time. We don't have a big enough staff to figure this out. 27 paid lawyers. And but the legislators said they put the burden on the individual with many who lacked education. You know, I mean, it was a robbery. We won a trial, hands down. The judge that we had was awesome. And then, of course, they appealed. And it was a close appeal at the 11th. And they came out, that's how they got it through. They said, we're gonna put in there that we're going to have this process where people can find out. We're gonna have an advisory opinion process. And the 11th Circuit bought that and said, well, it's not a complete bar. They can ask the state. Keep going. So we won a trial, lost an appeal. The reason we came with the CLE and tried to connect with any reentry programs, tell them about this process and just to have access to the people they serve.
What is CLE?
Continuing legal education, which for lawyers in every state you're required. Most professions, medical doctors have to do medical continuing legal education because things evolve and change and you gotta try to keep up. Okay. So we did the postcarding. Remember we did postcarding?
Mhm.
And we got a very sizable grant from the Legal Defense Fund. A friend of mine was like, hey, you need some help? So we wrote up a grant and we were able to and we would get out there and just try to share the good work. That's right. Was a great opportunity for league members not legally trained to be able to like really work together. And we also told people about it, tabling efforts. And then there's the postcard. We put a lot of time in trying to get images that were welcoming to many different communities. And what we wanted to say was, your vote can impact someone you love. Because people live their life not voting. It's like, well, didn't help me so far. You're like, hey, you know, school with your child, your elders, you with cost of healthcare, cost of prescriptions. And for that's something we share when we go out, the importance of voting. And what I tell people to do is you can tell what's important to the person that's at your table. First of all, usually they come up to the table, they have an interest, they want to know. You can assess them right off the bat. They're holding the child's hand. Oh, is this your child, your niece, or you know? Oh, that's my heart. They'll say, yes, I'm taking them to the fair because you know it's a public event. And you're like, well, did you know that the school board? I've had many people, they don't even know what the school board is.
Right.
Or that you vote, and that person's deciding how many field trips. Are they gonna have music? You know, all the things. And when you put those things together, they're literally grabbing the voter registration to register the vote. If they push in an elderly person, or you know, you just kind of touch around a little bit, and there's something that they really care about that they didn't realize their vote is going to impact how that person is treated. And we were able to get many other community groups do postcarding. As you know, we had a system where you know you would get with a church, a sorority, a civic group, and they would work with us. Okay, so we were doing better, and then DeSantis decided to turn up the heat on his trying to stop people from voting.
With the next one?
Okay, so I don't know, thank you for having back from the break. I don't know if people were able to pick up the little pamphlet that has the advisory opinions. We're gonna start talking about those. Here is an advisory opinion. And the first one we're gonna discuss is, has a numbering system, F2210. And you see it as the Florida Department of State, the San Court Bird, its native on it. And these are provided at the Division of Elections. You can go on an advisory opinions and they'll post them, which I think is super helpful. And it's good for those who want to do petitions for modification before a judge, because it's the state's analysis of the rules that pertain to advisory opinion process or petition for modification. It's the same rules that were listed in the Florida statute 98.0751. The statute that, put all the limitations on. They're following the exact same rules. So you can look at the analysis of the state and attribute that same analysis to the petition for the judges. And I just had another idea. You could actually, I recommend that people actually attack the advisory opinion rulings that comport with the case that you have. So if it's the Four Corners rule, and they're saying that's why this person can vote, these are the experts on this law, and that's what they're saying. Again, we still have judges who are unfamiliar with the process, so they know about it generally, but they never had a case. And what we're trying to do is educate and make people feel comfortable to do the right thing. So I'm really happy that the Division of Elections chose to put these out public. So as we look at F22-10, what they do is they cite the legal basis and they cite the administrative rule. And here, they say the person is eligible to vote. And it's because if you look at the bottom paragraph, because initially they're just citing the administrative background and statutory stuff. And here at the very last paragraph, they're saying based on our review of your records, adjudication was withheld. They were never filmed. Mm-hmm. They do go on to say, based on the case that we're aware of, but it's a little bit, I wish they would say that we've looked at your records and this is what we found. I wish they would put that next sentence, because they kind of make it still the burden on the individual. Even though they testified at trial, we don't have enough lawyers to do this work. It's too hard. We can't find the records. We need kept. They admitted to all of that. And it's unfortunate that they didn't go that far. So let's look at the next one, F22-18. So they cite the rule that the requester is supposed to provide the basic information and everything. And this person had numerous cases, as many of them do. So if you look at the bottom paragraph, what did it say? The adjudication for the 3 felonies are withheld. You were sentenced to 24 months of probation. You were also ordered to pay $460. They found that they violated their probation and they did a hard time. And told them the court ordered to pay another $200, so they owed $660. So they're going through and they're saying that we've looked at all of these cases and this is how much you owe.
Mm.
And then they go down to the second to last paragraph and say, the total of all these different cases and the fines is $3,750.65. And for that reason, you have to pay that fine before your voting rights can be restored. So this person could not vote, even though they had the benefit of some adjudication withheld. They continue to, commit felonies, and the totality of all of them, they still have money to pay.
Can I ask you about the fines?
Okay.
When they have a fine like that, what is it for? Is it for court costs? Is it for
It's a combination.
restitution?
Yeah.
Restitution.
What we can do is we'll see if we can find an actual sentencing document. We can pull up someone saying you look at their sentencing document, maybe on the computer, but it will have different categories on the sentencing document. So much for the fine, so much for court costs, but they all have to be paid.
Do they know where it should be paid?
Yeah, that's not an issue. You can come to the court or the probation office.
Okay.
Yeah.
So have you ever had a case where the fines are negotiated down
Well, that's what you go to court for.
after you get this type of notification?
Oh. This right here is the administrative process. They don't negotiate down in the administrative process.
But after you get this, could you then take?
Of course, you could.
Okay.
It's always available to you. The court process is
Right.
always available to you.
Okay.
Yeah. I don't know how a judge would feel since the state said you couldn't vote to override that. But the advisory opinion doesn't look at you're disabled, doesn't consider that you've been doing community service. Those are only under the statute that's presented to the court. So I would think a judge would say, well, they couldn't consider it, it's just black and white. These are the standards, this is what you're convicted of, this is what's in the four corners, and you didn't pay. That's all they're doing. They're not looking to see how you've improved your life or anything. So since they're looking at different elements, I would think it would be appropriate and acceptable to, if you were told that your record shows this is how much is owed, to take that same case and go before court, where you could present those other issues. Now, when we were looking at the cases and the person had nothing to show that they did anything to help themselves, we would say, it's unlikely the judge is going to let it away.
Mm-hmm.
And we would let them know, if we would try to be selective. And we rarely had someone insist that someone take a case when you're telling them the basis for the modification. There's none, because they list the reasons in the statute, which are petition for modification, for example, tracks exactly verbatim statute. And if you don't have any of those reasons, then you're just asking the court to do you a favor. So that's kind of how that is out. All right, so we were at 23.
23.
I'm sorry, 23. And on the back side, here they actually kind of complain that the person didn't give all the information in the last paragraph on the first page, but they go on to say, but we looked. Nonetheless, the division was able to find the following felony cases associated with the fine. one in St. Lucie. Instead of $743 in fines.
And 618.
Oh, yeah, and Blake's there.
They did pay some of the money,
Yeah.
$500.
Mhm.
So that left 243. And then they go to the sentencing documents at 800. And 618 in fines and fees and restitution. Our records indicate that the restitution has been paid in full, and you paid at least 618 in fines and fees and costs. You still have $119.93. And so it says, and the third paragraph up from the bottom, division of life and fine, take the amount of financial obligations, legal financial, related to your felony convictions in the above referenced cases, you have to pay $243. That's still really helpful information. Most returning citizens or persons with felony convictions, either they themselves can get that money up within a month, or they have family and friends who just pay it right off the bat. You know, it's like people with thousands of dollars in fines and fees and kind of stuff all around trying to get that done. Let's look at the one F25-1.
Can I ask you something? Once the fee is paid, and then you get a receipt, and what's the process after that?
So probably what I would do is take this letter to the supervisor of elections and show the receipt and make sure that they see that. So that they'll put you back on the voter rolls and you won't get mistakenly, someone come around and you're supposed to vote. And then you have to prove it, let it get cleaned up ahead of time.
It's called a challenged voter.
Right. Well, you would have had the supervisor of election on alert to know that that was fixed. Yes, sir?
I have a question about restitution,
Sure.
how it's treated in these circumstances, because it is not highly unusual, especially in Citrus County, that the individual will be sentenced to a term of imprisonment. Let's just pick out 30 months for the sake of being a round number.
Okay.
Isn't placed on probation, but pursuant to statute, there's a restitution order that is entered.
Pursuant to statute.
Excuse me?
It's not personal to the case, it's just a statutory thing.
That's where I disagree where the argument's gonna be, because, and I apologize for those, my name's Mike Graves, I'm a public defender for the Fifth Judicial Circuit,
Okay.
which is Lake Marion, Sumter, Citrus, and Hernando. There is a statute that requires the court at sentencing to enter an order of restitution, if restitution is owed. So it's kind of a tweener. They can't violate you, they can't send you back to prison for it, but it's ordered as part of the sentence, and you might have somebody who's done their 30 months of state prison,
Yeah.
but as a restitution order, $15,000.
Because they stole a car.
And then the argument comes up from the state, well, we're not going to waive it because the victim has to authorize it. You can't do community service. My argument to that, when I disagree with them, is though the statute says as part of sentencing, the real purpose for it was so the victim can take that order and get a judgment without having to go to trial, which makes it was done to facilitate a civil proceeding. I was wondering if your people have had any problems in dealing.
We've never raised that argument, but that you just presented what the actual purpose was. It's been black letter law. It says, and there's a whole paragraph under 98.0751 that talks about restitution.
Okay.
That was a major battle during the legislative session where they were trying to figure out what to do. And for those who remember, which many do, that was a big issue. You gotta pay it. or get the waiver from the victim. So I don't think it would be persuasive to the court at all that the reason we have restitution in the first place is to provide a civil means for the victim to get paid. Because it's in the four corners of the sentencing document. We were talking about how the battle of adding on interest. And in the division of elections, they track the statute and they give you the rules. If you go to the website, they actually say, whatever is in the four corners, you must do. Outside the four corners, no.
Second question is there anything specifically in the statute to deal with cost of incarceration?
There hasn't been. There's been no requirement in the statute. And I think that would be something that was for past sentencing documents is not included. Now, the law can change. That's something we all need to kind of keep our ears and eyes open to argue against. That to add the cost of incarceration, well, after the fact, it would not impact the voting because the law is clear. That's not in the four corners. But it's possible that there could be new sentencing guidelines that include the costs. And if that was put on the document that did the sentencing, then that would be one of the
That's
legal
huge.
fines. And
That would be huge.
Because it differs in all 5 of our counties, how cost of incarceration is ordered. In Citrus, traditionally, it's been done at the time of sentencing.
Oh, God.
ah,
Wow.
So if you're sentenced to a year in the county jail, you immediately, the court has found that you owe $18,250. It's cost of incarceration. I don't think it's really part of the criminal sentence.
well, I think that could be argued.
And
We have had successful arguments that that's an administrative thing outside of the sentencing document. Because the sentencing document is usually a form that is, promulgated off of state sort of general guidance. And there are additional things that are signed that are not in the sentencing document. I mean, that would be a good argument.
And that's what I'm trying to get the circuit set, as we had talked about the administrative
Yes.
order. We don't have one. And the form signed by the judge of fines, the order of fines, costs, fees, and assessments also includes the cost of incarceration, so it's in the same document. But that document was created by the clerk and is unique to the county. So
I would have to look at that and lay the statutory written black letter law beside it. And if there was a way to distinguish, then that would be something we can try to do. It's bad news that it's in the exact same sentencing document.
Yeah.
Because there are other courts where those kinds of things are outside of the document. And one of these examples that we have of what we're going to go through talks about. There was an additional fine that wasn't in the sentencing document, therefore for voting, you don't take it into consideration. So what you've described is all in one document, so that argument may go out the door, but maybe there's something else.
In that case, the clerks, how would you revise a clerk's document then?
You wouldn't revise the clerk's document, the judge would just say, based on my review, I don't consider that cost of incarceration to be part of the sentence.
So it's an interpretation then.
That's all court orders are.
Okay.
They're all decisions and interpretations presented to a deciding entity based on facts and the law. Every single court order is an interpretation. Every single one. Regardless of civil, criminal, sentence, it's all, this is what I see based on what's been presented to me. Okay, so 25, these are great questions, by the way, and it's helpful in a small group to go ahead and take them as we are looking to, it's more meaningful because you're bouncing off the advisory opinion we're talking about, so it's a good way to learn. So 25-1, Okay, they start out saying that you were adjudicated guilty of the bottom paragraph. Garland County.
But that's a violent offense.
It is, but the bar is for murder.
Okay.
Violent offenses, there's some of these that are not nasty. They're nasty, the person who looks, it's not murder, it's not a felony sex offense. They also say you have $200 in fines and fees. It says you paid all of your outstanding bills. And it says they put it in a funny way that you have to pay $0 to be able to vote, is what they say. They've been using federal law money. And the last sentence, we conclude based upon the information we located that you are eligible to vote. So here's an example of, and frankly, of the charges of battery of a law enforcement officer are not valid. They're ridiculous. It's like the cop got mad, and some little minor thing happened, and they make it feel like he beat him down. And it's usually, you're brushing past the cop and he's getting in your way and your shoulder hits his shoulder. Stuff like that. It's ridiculous. I mean, there are bad cases where people get hurt for real, but the majority of them are not like that. So even though it sounds like battery of a law enforcement officer, oh my God, no broken nose, it's usually some inconsequential touching, brushing. The cop's trying to grab you, trying to get away. They call that a battery. So, 25-3. Now, if the person had a good lawyer, that would be thrown out. I mean, my husband gets things like this thrown out all the time because the facts don't support the charge. The cop got mad, and they write you up. And maybe you had an attitude, maybe you had a mouth, maybe you were disrespectful, but that's technically not against the law. But they'll, it's what goes down on the street. Okay, so let's look at 25-3. Okay, this one is shooting into or throwing deadly missiles into a dwelling. Possession of a firearm. Again, not a murder, certainly doesn't sound good, does it? $225 fines. Hold on to say, on a certain date, you pay the $225, and therefore the amount that you need to pay to restore your voting rights is $0. And then they go on to the next one of controlled substance. And there was a fine, and they paid the fine, $955. The amount you have to pay is $0. Accordingly, if you look at the second to last paragraph, we conclude based upon the information we located that you are eligible to vote. So it's interesting the types of things that might raise your hair in the back of your neck that people, with regards to voting, they can vote. Shooting a gun, that's into a dwelling, telling them you can kill. But that person can vote because there was no murder and there wasn't a felony sex offense. And they, under the law, paid their fine. And they did their hard work. They had that's why I selected some of these, just so you can kind of see for yourself how they're analyzing things. 25-4, they talk about they were adjudicated guilty, had $660 in fines, a total of $6,400. And you were ordered to pay $800 to the victim. Our records indicate you paid the $660 in fine. The restitution, $6,400 to the victim, has not been. So therefore, you must pay that before you're eligible to. And they cite the statute. So you have now completed your sentence. We conclude based on the information we located that you are eligible to vote. Does this have a light? No, this is a mic.
Yeah.
Okay, so let's go to 25-6.
Do you need a light?
It's okay. Not for my glasses off. So they're saying, you were convicted of practicing law without a license. As your sentence, you had to pay $762. And it says, at this time, you still have to pay the $762. Unorganized fraud practicing law without a license, forgery, $932. And then restitution, $80,000,
14,000.
quite a bit.
24,000.
Yeah. And then our records do not indicate that you have paid this amount, nor have you provided the division of proof of payment. That they have to, in order to get their voting rights restored, they have a total of $25,000 with regards to this charge. And then they have a federal claim, federal charges. So basically they're saying you are ineligible to vote. Because they haven't paid all the fines and fees.
I have a stupid question.
Yeah.
When the amendment passed, does the legislature have the right to change what was passed in that amendment? Or is it because there is nothing that tells the legislature that they can't do that?
That's part of the argument that we want to try. That the amendment spoke for itself, that it was self-executing immediately in implementing legislation. There are some laws that are passed that don't say how they can be used. And so there's authority to pass implementing legislation.
Okay.
Because Amendment 4, which was written by and looked at by many legal experts, it literally says upon completion of your sentence. It doesn't say upon your presentation of evidence to the deciding authorities. You don't have to do anything. You except finish your sentence. It didn't need any implementation. So that was argued. But what happened was in the Supreme Court review of the amendment, which is back up a little bit, in order to place an amendment on the ballot, you have to get a certain number of signatures so that to show the Supreme Court, it's not like purple cats, get fed tuna every day. Who cares? And not a lot of people are going to sign on for that petition. So they don't just let any old thing that a group comes up with get on a ballot. You have to show significant support. And usually it's in the tens of thousands. I think it was like 90,000 signatures. And it could be 90,000 spread over certain counties. So it's not just in South Florida, it's spread around. When you hit that magic number, then you have to go before the Supreme Court. And they are looking at it for two reasons. It's clear, and it's one issue. Because sometimes it can be like two or three issues bundled together. So it's one thing and it's clear and not confusing. And so as part of that, at the oral argument for that process on the Amendment 4, one of the Supreme Court justices asked, what about all the financial obligations and the rest of it? Is that part of the thing that has to be completed? Unfortunately, and they might have done it anyway, but the person who was arguing this before the Supreme Court said yes.
No.
And they held us to that. Even though that wasn't what was contemplated. And they would go back, and the legislators would go back. This passed clarity and everything because they said yes. If we said no, then, maybe they wouldn't have had that argument, but the person was trying to get past that requirement, the threshold. And they conceded that they thought that it was, but all the people that wrote it up did not.
That's huge though. One person?
The advocate, your lawyer speaks for you. I mean, it was a stretch, but that's what they stuck it on. And we appealed, we won a trial despite that. So, an objective fact finder, lawgiver said this is literally a legal impossibility because the records are not kept. The state itself says they can't find the records. All of that. So, but on appeal, they said the advisory opinion process takes away the impossibility because you can ask the state. And we talked about how the state was not doing very many and the wait would run. The time that people would have to wait is 20 to some odd years or more. So we look at 25-7, grant that. $500, fine and fees, and pay restitution. However, public defender, Mr. Mike, if you look at the second page at the top, this might be a question.
Yes, I read it, I don't like it.
However, the restitution amount that you were ordered to pay does not appear within the four corners of the sentencing document. For purposes of voting, restitution is not part of the calculation for this case. The division also applies the first dollar policy to give effect to the requirement. And that's the statute, which they wrote 98.751 sub 2. Financial obligation required to be paid for restoration of voting rights include only amounts specifically ordered by the court as part of the sentence and do not include any fines, fees, or costs that accrue after the date of obligation is ordered. Again, the leak rule as part of the sentence. More specifically, automatic restoration is effective when an individual pays, see, automatic and saying, so they're admitting themselves, there was no reason to have any implementing legislation, but automatic restoration is effective when an individual pays an amount towards fines, fees, costs, and a restitution in a felony case that exceed the amount ordered in the felony judgment or sentence. The division considers whether the amount due for fines, fees, etc. has been paid to the court and does not consider whether the court has applied the payment. In other words, if they applied it in different categories, we don't care. We're just putting it all on what of interest and things incurred after the sentencing. We're putting it all on the sentencing, the first dollar roll. Though the records indicate that you still have a remaining balance of $224 for purposes of voting, the division considers the amount paid in relation to the fines and fees initially imposed. So they're excluding, I guess, that part that they said was outside of the sentencing. So then that person, with regards to this case, they can vote. Then they come down to another case.
So they set it aside?
Hmm?
They set it aside, 224.
They said it wasn't part of the original sentencing document. They did not set it aside. The only entity that can change the sentence, remember? Is the judge. This is administrative. And I like, might sound like, what are you talking about? But a court is when you present evidence and the judge can change it.
So
The
this
judge
is,
can set it.
this is paperwork that goes to the court,
No,
supervisor elections.
this is a whole different process where you get a ruling, but it doesn't go to a judge. It goes to an agency. Like the difference, like if you deal with the IRS, that's not a court. But they can still make a lot of decisions. It's an agency created to make these decisions. Therefore, they can give you an opinion based on the evidence. They cannot disregard. They cannot, in court, the judge can say, yeah, I see on paper you owe $5,000, but you've done so much work. I'm gonna give you credit for that. That's essentially setting aside or changing things. You see what I mean?
Yeah, got it.
These administrative agencies can only follow guidelines. It's more like a formula. They follow the guideline to see if you can vote or not. They can't change and take away a part of it.
They just get the information and report it.
Yes, but these are probably lawyers making these decisions. And I was impressed that they were, even in cases that sounded kind of messy, the law enforcement battery, the person who shot the gun, they can vote. They are following the guidelines. They're not looking at the substance of the felony, which a court could. Court could go, I don't want someone shooting a gun. I'm not gonna give you credit for all that. They don't have to.
But here you have the division making the interpretation rather than it saying to the judge, or it says here, the division considers the amount paid in relationship to the fines imposed.
right.
Okay, so they're making the interpretation
Exactly.
rather than the judge doing anything. They're just saying,
Two different systems.
yeah,
I'm using the example of the IRS. Do you understand that the IRS is not a judge? Do you accept that? Okay, same thing. This is a division, an administrative part of the government. I think when people get letters from the IRS, do you understand the judge did not send that letter to you? Do you understand that? Same thing here. It's an agency set up to make decisions based on facts and their interpretation.
Yeah.
And if you want to fight it, you go to court. But think of it like the IRS. It's not a court. It's not a judge. They can make very important decisions that impact your claim, but it's still not a judge. So two different systems trying to deal with the same problem. And the judge usually has much greater authority and power to make changes. Generally, the rule. Now, if you get a nice administrator through the division or the IRS division of election, you're right. You could just luck out and have someone who wants to interpret it in a certain way. Well, then there's no need to go to court. You're going to ride on that way. Okay. So they go on to say this person had other fines and fees. So they have more things that they have to do. And they end up saying you're ineligible. So you'll find people who have started the process of dealing with their pension. You know, and sometimes if you were to find out when people get convicted in a sentence, oftentimes family members are nearby and they're invested in trying to help. So there's a little boost. You'll see a payment within the first 3 to 6 months. And when family members do that, I know I've been in that position. I'm going to help you get this. Here's $5,000. I'll pay it for you on this or that. And then after that, we got you a job, we got a situation, you being responsible. Family member may say that. So you often see a start of it, and then unless they're really dedicated to it, or if it's a relatively small amount, they complete it. So we have 25-8, and it says oxycodone. And wow, that's one of those massive statutory crimes. Ineligible to pay over $50,000, which few, if any, people who have these felony convictions can handle that. That's not right. 25-12, possession of cocaine. They got about $1,300 in fines and fees. On the next page, they paid $125. So then at the end, it says you're eligible because they hadn't paid everything. So again, they just add up the fines and fees for the different charges because you have to pay all of the fines and fees for all of your charges. Even if you've taken care of one, if you have one or two more, then they're not paid, then you're stuck. 25-13. They had $1,400 in fines and fees. The next page, they said, you pay more than that. They probably paid interest and administrative fee because they paid $1,500. Right. And so on that charge, they're eligible to vote because they had the loan charge and they paid over. In terms of voting, I'm sure it was some additional interest, whatever, but they paid it whenever they got the chance. 25-14. Food stamp fraud. And they were given a fine of $1,300 and some dollars. And it said that they have to pay the $1,300, and they paid some of it. Right? But they still have $773. Again, it's still very helpful. I mean, that's a lot less than some of the others. And with the person's ability to get their own money or go to family and friends, that $773 is something that many returning citizens would get support from someone they care about to be able to pay them now. The next one, 25-15, it says marijuana possession, about $1,200 in fines. Here's another thing I forgot to mention specifically. Cases are consolidated. And that means that however we treat this case takes care of the other case. So let's go on and say, let's see what they say. The case was consolidated with another case. So they're analyzed with that case. The state filed a no information notice. In other words, they chose not to pursue it. So this case was consolidated with another felony that there was a formal document saying we're not going to pursue this. And then it goes on to talk about some other cases. You were not prosecuted for this felony. I'm looking at paragraph 4. Only a felony conviction makes you ineligible. So just because you're charged with a felony, if they don't go to the other end of the process and get that conviction for dropping the case, make it a misdemeanor, no crossing, that which means we're not going to pursue. And it could be problems with evidence. Could be that they're just overwhelmed and they have a lot of violent crimes they need to prosecute. Usually a combination of the two. And public defender knows what sort of kind of cases we've seen that. So again, it goes down in the paragraph 5. Another case was consolidated. This person had a lot of study. Finally, something stuck. If you go to paragraph 9, it says that they paid $32 on a $1,400 plus fine. So in the end, even though they had 5 or 6 felony charges that were consolidated or no cost, which is great, they still are eligible because they had over almost $1,400 in unpaid fines. Yeah. So, but this is how they're analyzing it, case by case. So consolidation means that we're treating it like another case, and then that other case had favorable treatment, this charge does too. If they know us, there was no conviction on that charge. This person, for whatever reason, kept offending, which people have seasons in their lives when they're doing criminal acts. So it's not unusual to have 5 to 10 charges, or you might have had 30 charges, but they only pursued 10, you know what I mean? And so it's not that unusual to have someone have that season and have a bunch of them, but this one is fairly close to getting fixed. So it's, even though some get told no in the end, the analysis really helps. See what I mean? So 20 by 16. They had their probation revoked, but they completed the sentences. However, the court maintained the adjudication without judgment, only a felony conviction. So we go back through and there's still things where they didn't pay. And their paragraph 4 talks about a misdemeanor. You're kind of going a little faster now when you get the hang of it and you want to come through there. But this person had a season of charges. One was a misdemeanor, never was a felony. The other one had adjudication withheld. That one wasn't a felony. So let's go to the end, what they say in here. They say in paragraph 12 that through all their charges, there were enough that stuck, and when through the process there was a conviction, and they had over a $6,000 fine that was not paid. But they kind of excluded a whole bunch of stuff, right? So that's what I want people to understand, that they are excluding it. But you could use, back to that, on a petition for modification before a court, if you're 15, right? Before a court, you can use the same analysis. It was consolidated. Adjudication was withheld. That means there is no felony on that charge. And so you could go before the court with that same analysis, and not necessarily this case, but if anybody saw a case like that and you analyzed it, and basically being down to, less than $2,000 in fines and fees, that's a reasonable amount for the judge to, if the person has done anything helpful in life, or has disability, that would be a reason to go to the court to consider changing that so they can vote.
How does a person who is sitting in jail know all of these things?
There was a lot of altercation when this went through, and people's memory is like 2 years long, right? 2 years old, and about 20,000 people become convicted felons a year on average in the state of Florida. So those people may or may not know, but this is sort of the education we talked about that the league has always done. So aside from the fact whether any league has a lawyer that can actually do the review, we can tell this to the people. We can reach out to the prisons in our community and ask to go and speak on these things. We can, write letters, and again, personally, I'm very interested in this. And people can reach out to me, and I'll either personally get someone to help me state that, and I would think that I'm considered one of the state's experts on these topics. So I've been involved from day one up until now. So I'm not going to give this up. This is going to be something we can continue to work on. But as I educate other lawyers about it, they become experts. Right, so what I'm thinking in my mind is to create a circle, not directly under the league, but just a circle of experts that people can call or send an email. I'd like to take this case, what do you think? And actually the Florida Bar supports this. We have mentors on family law, and they're doing the exact same thing, and I might look to the Florida Bar, which we've had good relations, the league. And again, I would not be doing this under the league, but Cecile Scoon has good relations with the Florida Bar as a representative of the league, and I would be representing another group create a not-for-profit, which I created one before that, for children, to do art with children, which is my undergraduate interest. But, there's things that we can do to pass that knowledge along, even if it's not technically under the lien. It was our baby and something we created, but that's the present leadership has said we don't want to continue the whole process. Yes.
So the applicant makes this request based on a specific case of theirs that they're aware of, or does the Division of Elections staff?
The document literally says, the burden is on you, the statute says, you tell us what you've done.
So these ones that have 10 in a row or something, the applicant
They
identified.
should have, not all. In some of the paragraphs that I haven't read to you, it says, you did not provide us your entire record.
Okay.
We looked and found these others right here,
That's
and
the
we
problem.
analyzed these 5 and the 3 you said. Again, why didn't they? They don't remember, they don't have the records, it was too painful, da, 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 da. They have a 9th grade education, they can't read.
That's right.
A lot of reasons people aren't able to present everything. According to what I'm reading, the state always looks. But the statute says it, and it says it in the Division of Administrative, it's your burden. So you were saying this is what I know. That doesn't mean technically that there are not other things that you don't know. Okay. So on this one, let's see, 2517, in the end, they're looked at all the charges. And quite a few of them, they're zeroed out. Because they paid them. They paid a lot of them. And in the end, they have 3,200, so they didn't pay them all. So that they're looking case by case to see what it's done, and then they add it all. The next one, 2518. They said they were ordered to pay 783. They paid about half of it. So this person is ineligible. 2520. You note on your request that you had your voting rights restored over 30 years ago. You did not provide any documentation showing proof of clemency. We have checked, they're checking themselves. We have checked with the Florida Commission on Offender Review that handles out the clemency. You have no record of clemency. So this person has an astronomical fine, probably a statutory, of $57,000 plus. So they're not able to vote. 2524. They had in first paragraph 1,500 in fines. And they paid some of it. They go through and it says paid. Paragraph 4, they didn't finish paying. So you know the answer is going to be your account people. Once you take it for anything, 2526. Trafficking and illegal drugs. They have another one of those statutory fines. You see anything over $50,000? Statutory. As in like anybody with that conviction. Not personally. So they have 53. Not surprisingly, they're eligible to vote. They paid on some. They paid about 5,000, but not enough to pay the whole thing. So that's one that if a person was doing a lot of positive things in the community, they were disabled and really couldn't do a lot of work. That's one judge might consider. See the difference? Administrative, they can't take that away. You paid it or you didn't. It's in the pot or it's not. More black and white. There's some interpretation in the administrative, but not as much. The judge can look at the individual, the whole person and everything.
I have a question on how they research the data. Is it, for instance, the applicant or something? Are all those fines underneath a social security number or a prisoner's number, or what is the unifying arching, how does,
That's that slide, earlier that we mentioned it. And there are places that you can go, the Department of Correction
okay,
is one, and then you can request a $24 report
okay,
from the Florida Division of Law Enforcement, and that will give you everything in the state of Florida. Now, if the person says, it doesn't tell you that they have a murder conviction in Montana, most people know they've been charged with murder. They know, regardless of looking at records, that's so significant. That just never happens, that some serious offense they didn't remember. So I've never heard of that, and I think it would be highly unlikely. I have seen people forget which county they were in because they were right on the county line. Was it Leon County or Bay County? And they'll just take care of Bay County because I never had anything in Leon County, and then you actually look at the records and boom. Oh yeah, that one time we did go cross the line and went to the grocery store and rob them, whatever. Right? Those kind of memory lapses are gonna happen, but not major ones. Okay, 25-27. Says follow no information. That's another thing of saying no process. They didn't prosecute. So on that first one, let's go down. In paragraph 4, we see the $210 remaining. So that's what they said. Pay the $210. That's a key to voting. Most people can get that $210 within, if not immediately, from a friend or family, or even out of their pocket. That's something that's reachable, right? So there's still been a great benefit of going through the process. I'm just saying, it works out that we can use this lever. And the League of Women Voters is actively supporting this and telling people, all league members, regardless of being a lawyer, tell the returning citizens. So this is part of what we can talk to them about. And I'll talk to Jessica, the president, and ask her, because when I created this, we were still actively involved. I'm trying to remember. Yes, I was the president with Debbie. And we were gung-ho on both sides of the modification. Right, but it's still a good guidance. When you get training from the bar that's approved, the training is approved, it's approved for like about 2 years. So we're still within that time frame. So even though the league is not, again, doing the referrals and everything, come live on training. But I'll talk to Jessica and ask our president, state president, if she thinks it would be helpful to do another one. It's very similar to this, that just focuses on the advisory and gives more specific instructions to league members to tell others about it. Because they're not recommending that league members fill out the paperwork. But if you can explain it, it can encourage other people to assist people to fill out the paperwork, or the person themselves, or someone in their family as well. So anyway, that's future thing. 25-28. It says there was no information, it was not prosecuted. They have some remaining, so it ended up saying that they're ineligible because they didn't pay everything. 25-29. Theft. And they've sent them. They were not in the first one. And paragraph 2 was a misdemeanor, was never a felony. Paragraph 3, misdemeanor. Paragraph 4, they were given a fine that they paid of over $500. And they paid the fine that they were supposed to be, going through the whole thing. And in the end, after they had quite a few, there's a $1,000.73. One of these, and this could be the one, they're in their own argument, they had not given full credit for everything. I think it was one, and I'm gonna double check. But where the person had overpaid on one of their fines. And remember, first dollar? I don't know how it would work, but there's an argument to say, if you pay $500 on a charge, and you were only supposed to pay $250 based on the sentencing document, other was interest and so on, that this doesn't count. Could you take that extra $250 that were attributed to that charge A and put it on charge B where you didn't pay? Good question, right? And I've not seen the answer to that, but in the one case that I was reviewing, sorry, 50, that is, and they did not carry over the overpayment to a different charge. But that would be something, if I saw that, I would tell the judge. Because if they had carried it over, they would have paid everything. The amount the state got out of that person was over what was in the sentencing documents. Maybe not on the exact charge. You see, that's the kind of thing possibly a judge could consider. Do you know what I mean? Because the last paragraph of 98.0751, which was the statute that talks about the methods to modify, the very last paragraph just says the judge can decide to do it. For, it doesn't say for good cause, but basically, you see what I mean? It's kind of a little bit of a catch-all. We try to hit the ones that are specifically mentioned.
Yeah, number two.
So let me ask a question.
Mhm.
So if this advisory opinion committee is going through all of these and they see these kinds of areas that are open that can be discussed or brought before a judge, will they refer that?
No,
Okay, so it's strictly up to the client themselves to.
they absolutely do not communicate with the judge.
Okay.
Nobody does that.
Yeah.
No,
No, I mean, not necessarily communicate with the judge, but maybe set it aside to forward it to an entity that would take it up with the client, whether it's the client's original attorney or anything. So you just get a letter. Okay. So it's really up to you then to pursue that on the court level. So then, are we then talking about incurring additional court fees to take this before a judge?
Well,
Say, would you take a look at this?
Isn't, you're filing it in the same court where you were sentenced. So it's already there.
Any additional?
There has no coverage. Okay, we're almost done. 25-31, you guys are great.
Yeah.
25-31, paragraph 1. No information, didn't proceed with it, no conviction under that one. There are 2, they paid their fines.
Yeah, but it was more than that fine.
You see what I'm talking about? So they may have gotten a good job later on, after all the interest and everything was paid. And they were told by the clerk, because it was the law at the time, you gotta pay it all. So they paid it, this might have been the one.
Mhm.
And then in the end, yeah. 575, this is it, this is one of, just tell me that. I gotta make a note, it's 25-30. I might write them and ask them, did you note that they overpaid?
Yeah. Number 2.
So this was the case that troubled me so much. They well overpaid the amount that remains to be paid, but it was on a different charge. Page. Because that's worth a question to the Division of Elections. Can you clarify? 25-34. Clemency. See, that's interesting, right? You actually have a clemency on one, but then they went on and they had
Jeez.
a whole lot more. And there were no informations, with some of went away. We know at least one fine. And then there was a lot of consolidation, so they were rolled into one that got favorable treatment. So let's go to the end decision. And after all of those voting charges, it's down to $872. Again, usually something that they can, with time, deal with very quickly and be able to go. So this person with what, 30 odd charges, several were consolidated, you know what I mean? So that's what really helpful when you actually look and see how things are. Because again, many people have a season when they're in this bad cycle of breaking the law. So when they finally realize, I don't want to be locked up, I want to raise my family, the young man says, I don't want to die in prison, or my mama to die while I'm in prison. This happens, it's heartbreaking. I'm going to straighten up so I can be a part of people's lives. And when they finally do that, if you just gather up all the little nuts and things that they have, then they can still make it. 2540. Also, I want to say, Governor Scott, which I'll send you this video, I don't think I put it in here, did a report. He was quite conservative. He did a clemency report that showed when people got their voting rights back, their recidivism rate went down between 30 and 50%. So that's a public safety issue, which we actually used that when we were getting Amendment 4 petitions to be signed in and advocating, once it got on the ballot, vote yes for it, right?
I must
So
have killed
30,
them.
you said 30 to
50%, yeah, I'm gonna find the exact link. Yeah, and there's another state that also did a survey, I think it's Nebraska or North Carolina, one of the end states, that also did that. Vicki, can you remind me to try to get those documents to you to show the community benefit for voting? All right, 2540. They had fines and fees for $400 and some dollars. They didn't pay it. Oh, they had a massive one. What?
$1 million restitution.
See. Yes. Wow.
That's a grand theft.
And they paid 16,000 for that, the public building. That's one of the statutory ones and probably a federal case. They're the ones that
That's like what the
the feds are Duval County. Grand theft.
They must have stolen aircraft carrier.
Wow, I don't even know what that could have been for. That's crazy. All right, 25-41. Did they say what the charge was for? Yeah, they did.
Grand theft.
grand theft.
Yeah, but how would you have that big of a restitution? All right, 2541. First adjudication was withheld. No felony convictions whatsoever. And they're eligible to vote. And they paid $600 and some dollars in fine. 2542. Burglary of a dwelling. Assault and battery. Yeah, that doesn't sound nice. But they paid their fine on that charge. And they paid their fine on another aggravated battery. Eligible to vote. Again, sometimes you look at the charges and you're like, you're not gonna let them vote. But by the guidelines, they don't consider, unless it's a murder or a felony sex offense, they don't get to what did you actually do. 2545, no cross, they didn't prosecute, they did the charge and did nothing more with it. And they have they paid a lot of the fines and fees. But they have a few, one was $44, $71, and the sentence.
$660.
Yeah.
A lot of labor.
Yeah. So they just had a modest amount, 660, back to that. So we were able to analyze, and they were almost there. 2547, And the habitual offender thing. Okay, they said in their refund, they paid their fines and fees. You're eligible. What? The cumulative 2548. They said.
Not a felony.
You were not convicted of a felony. Okay, so they didn't say whether there was no cost or whatever, but they said you were eligible to vote. Our last one, 25-50, says you're not convicted of felony. And so that first charge, they paid the fine and fees on the second charge. And so paragraph 4, they got hung up. They had a fine of $1,000. And the remaining amount was 157. So we know they're gonna say you're ineligible. But it's a very modest amount we should pay. So we kind of went through all of that because I think reading their own words, it was very powerful for me when I was doing my research and actually see their analysis that they wrote, they signed off on, and the breadth of the charges that people had, and that they truly did not seem to be looking at the substance. I don't like what you did, they were just looking at did you pay it or not? Is it in the four corners or not? Was it null cost or not? Was it shown into a misdemeanor or not? They were literally, in my opinion, fairly objectively following the rules, which I didn't want the rules, but the rules are being followed. So again, this is a process available to the individual. And for those of us who want to take on petitions for modification, I hope it's perfectly helpful to submit this to the court if there's a similar case. You see what I mean? And maybe the amount of the fine is just so big they can't pay it, or it's $2,000 or $3,000 and they're not going to be able to pay. That's when you'd go to the other community things that they had done. Yeah. Well, I want to thank you all for coming. Each one of you is really important to spread the word to others. And some of us have more breadth, Mr. Mike, that can really communicate to others. And I'm happy to try to facilitate, the training process, whether it's a Zoom or in person or some other pathway or discussions about how we can connect or, this is my passion. And just honestly, when I heard from Desmond Meade, and I was fairly new to being really involved with the league. I've been a league member for a long time because one of the lawyers in town, really nice lady, said, "Hey, so why don't you join the league?" I said, "What do they do? Should they do forums? They teach people about things. We don't pick sides. We just want everyone to be." I said, "God, sounds good. I'll do it." So I was the volunteer raising my kids and husband work that would turn up when we had a forum, and I would do research on a big newspaper and find a couple of topics and write a few questions. And I would turn up and I would say hi to the people that came to the forum and show them where to sit. There's a water. I was one of those involved in one small aspect of the league, an important aspect, but I wasn't in leadership, policy, none of that. And when I went to my first convention or lobby days in Tallahassee, like, come on, and my kids were a little older, I went and I heard Desmond Meade from before the Rights Restoration Coalition. He's running for governor, by the way. So he's not technically in charge of FRC anymore. There's other people running, he has a board. But I heard him, and this could have been 20 years ago. And when he explained the whole history and that this was a remnant of slavery, I felt like I've been hit by a 2x4. That in this day and age, there was a law that was an attempt to basically extend slavery past the proclamation of liberation, I was sick to my stomach. And at that day I said, I'm gonna devote myself to try to take this log out of the eye of the Floridians. And mixing my metaphors again, I'm really good at that. So it's really deep down, you know, it's important, and it's something that I'm grateful for your time and attention, but it's well worth our not giving up and continuing to try to resolve these terrible issues. Yeah.
What's important is now that we've gone through these cases, to go back to this document makes it more interesting, you know, to say, okay, advisory of how to use it. You know, who's the RC? What does RC stand for?
Returning to the discussion.
Okay, right.
Ask you a question.
Yeah.
So after they do this and they have fines and maybe they didn't know about it, is there repercussions to this? Like, you know, now the state comes after them?
No, they have not been any of that. Most of them have not been able to pay the fines for
Years.
tens of years, yeah. Yes.
Most individuals know there's a fine, they may not remember it. You know, if you're in jail, what it's been my experience in my 44-year criminal defense lawyer. I started at 7. I'm worried about the state prison sentence. But more and more, your lawyer goes over with you now, you're gonna order this amount of money. Or you're gonna owe this amount of money when you get out. Court order is part of the plea. It's important because if you don't get into the clerk's payment plan, make the efforts to pay it or pay it all off, they're gonna suspend your driving privileges. Okay, and what I'm gonna, part of training my 70 lawyers that work for me, and we're appointed to about 30,000 cases a year. This is part of that discussion with the client and what I call the ancillary consequences of your plea is you can get the right back to vote. You can start that journey towards being, you know, just like everybody else that lives on your block. Because when you're paying your fines, your fees, and your cost, okay, you're working towards that as well. It's just another reason to do it. And you know, have available and give to them the website so they can go get, but yeah, they know they're there, but I also want to try to see if we can make some adjustments in the way that sentences are issued. Okay, and I'm sorry for.
No, this is fine. I mean, we're done with the actual training. Now we're having a conversation.
Historically, in the judicial court, I've only been there since 1982. Practically before that. I mean, there's an old saying in Florida, you know, the farther north you go in Florida, the farther south you get.
Yeah. Right?
Okay, and the Fifth Circuit has pretty much been considered under that as far south. I mean, there, example, I've had kids that I've known, I mentioned by name, passed away, so he would find somebody the maximum fine if he sent them to prison. Not with any thought that that person was going to pay the fine, not with any thought because his position, they're going to pay it, so what difference is it going to make to them? It makes my statistics look better at the end of the year about how much money I fined people. You know, so it really didn't have to do with the consequences of what you did or the severity of what you did. So I want to start working with my folks. That's not as bad as it used to be. Okay. But let's work on sentence structures when things that doesn't happen anymore. That the fine actually, if it's punitive, matches the severity of the offense. And if we can in the original sentence say, Judge, if you're going to give him a $2,000 fine, let's at the original sentence say, or it can be done with X amount of community service work.
Yes.
Because that way I wouldn't have to come back to the court paths to do that again. So let's try to do things.
Brilliant.
So
I love that, because I think the judges are accustomed to that.
Right.
That's something that they see, and many of them are in the civil division before, you know, with a contract dispute or whatever. They're accustomed to, you know, taking this and letting it satisfy that. That's part of what we get trained on.
If it's kind of judge, you know, the chances of you getting this monetarily, because let's face it, you're trying to fund the criminal justice system on the back of the most impoverished citizens, which isn't a particularly good business plan.
No.
But if we get folks doing community service and getting involved, there's a benefit definitionally to the community
Recidivism.
rather than just setting out a judgment against them, which makes sure that they never get out.
Mhm.
So
Yeah.
that's one of the reasons I'm here. Another thing, when there was question regarding how do you find out, one of the, I think the best sources to find out about somebody within the state of Florida, their criminal record, and to determine the errors that are not infrequently made, is go to the county clerk's website. They all have it now, where you can basically go over their criminal records and have what the sentencings are. And since most counties now have a payment plan that you get into, they'll have in there what's owed, what's been paid. And I want to then also deal with, because I think it's something you highlighted today that made me think of, is when you're talking first dollar in, that's not exactly correct. And I know that because the first $50 goes to pay for the fee to determine whether the clerk's fee to determine whether you qualify for the public defender. I know that because that's the only $50 of all that money that goes back to the public defender.
We've had some judges, because of those statutory fees, actually did try to force you to get a waiver from the public defender.
Yeah, and I get waivers all the time. Won't waive the cost, the state attorney's office.
What are their costs like?
Right here, it's $250, which is above the statutory maximum, but that's per case. And part of the sentence structure again would be, and you're exactly correct, when you're talking about consolidation, it's not exactly consolidation on the rules. But if I have a client who has been charged with 5 different thefts and 5 different times they went to the pawn shop on that stolen property, that's 5 different grand thefts carrying 5 years apiece, 5 different dealing in stolen properties, which carry 15 apiece. But we're going to resolve that case all in one. And when the court says, I'm giving you a $2,000 fine in this, but all of the sentences run concurrent one with the other and not consecutive, so you don't have to do your time. Fine is part of that. We have many clerk's offices, in spite of that, now reflecting you owe $10,000. When in fact the intent of the sentence was, and part of the negotiation, was you're only going to
Would that be, do you think that merits training, you trying to get up training to the clerks of court?
you can try.
Yeah. I'm trying to think, just gathering information. We can continue our conversation by email.
We're getting there. Okay. Each clerk being an independent constitutional officer, they kind of run their own shop.
Right, but they have conventions too, so it might be beneficial.
Yes.
To see if we can get ourselves invited.
Yes, and that would be very good, because
Just to expose them.
the more we can get it right to begin with, the less we have to come in and modify, the less the ancillary consequences, and the more we can give a known path to people.
Yeah.
To become beneficial members.
Right.
I can tell you that the path you do not want to take is to have somebody fill out a voter registration application
Right.
and check the box that they're not felon.
Well,
Because that's another felony.
then you have to vote based on that felon.
It also seems counterproductive to take their driver's licenses when they owe fines.
We've already
and directly affect their
14 years.
ability to even be able to have a job and to make enough money to pay fines.
I remember when all this went down because I was very active in Neighborhood Watch. And I was the elephant in the room that everybody wished would just like go out because they were trying to make the 3 strikes rule. They were trying to make everything, every misdemeanor. They was like, we're going to do it with misdemeanors. We're going to make everything a felony and then we're ever going to commit a crime again. And then that didn't work. So we're going to make every felony a federal felony. And I'm like, what are you people thinking about? Nobody will ever be able to get a job, which means if they can't get a job, how is they going to feed their masses?
Or housing too.
It's not about justice, it's
How
about
are they
punishment.
going to accumulate generations of wealth to get out of poverty?
I think these kinds of conversations are really helpful. And I'm going to see if we can get the different leagues to consider different ways that we can attack the problem.
Yeah.
One is educating the judges. One is, our idea that we had at the league was connecting with the public defenders, connecting with the legal services. And we've done individualized training with legal services. And I think that's the way to go, is to spread the word and take away the fear factor. I don't know anything about that. I'm a bankruptcy lawyer. I do family law. You don't really want to stick your toe in something where you don't have any guidance.
You can reach judges. I mean, I will grant you that it is one of the most difficult things I ever did. But when I was in Tampa, I volunteered with the police department, which because their traffic division was like that. I ended up representing them to the community traffic safety team, and we instituted the red light running cameras. We met with judges. And I don't know finally if it was just they didn't want to meet with us again or we actually convinced them. But we got them to endorse the program. We worked with,
What was your organization?
at that point I was with Neighborhood Watch, Neighborhood Association, Community Traffic Safety Team. I had about 5 different hats. I had no time yet. But red light enforcement was impossible because if you think about it, if somebody's running a red light, that person goes through the red light. If an officer has to see them run the red light, they have to be behind them, which means they're going to get T-boned in the intersection. So the volunteers for red light enforcement were like 0. You couldn't even do it from across the street because there was a possibility that, God forbid, one light was out of sync with the other. We went to traffic court because chronic offenders knew that if they went to traffic court and appealed it, they were likely to get their charges dismissed and just have to pay court costs, which was fine for somebody that was a first offense or whatever. But what happened was the chronic offenders and sometimes violent offenders, people who were chronic DUIs, they would go and we told the judge, law enforcement is screaming bloody murder. And so we actually got them to think about, all right, if an officer comes and says, this is this and this and this and this, we'll listen. They didn't say we're going to do it, but they did take a greater weight and put it on the officer's testament. But the officer had to know their facts when they went in for.
I just want to say again, thank you for attending, and we'll be preparing lunch, and we'll eat in here. So as soon as we're done, we'll assemble and get our plates. For you, Vicky's gonna speak. Okay.
Can I ask just one last
Yeah,
question?
too.
If a returning citizen isn't able to modify down the their legal financial obligations, what financial resources are available? Because I think there are some that, are there that assist,
The Florida Rights Restoration Coalition got over $1 million donation, and that was heavily challenged in the law. People were saying, that was, I think it was Bloomberg that was really excited, and his people did that. So there have been, after that big stink of, what are you doing? I can't remember what they thought they were gonna charge him with. But the flow of money into FRC to pay the fines and fees completely dried up.
okay,
So I think FRC does have a modest amount, and they do pay some, but nothing like they did before the threats against donation.
I was speaking with a woman yesterday, and I can't remember the name, but it was a reentry program. I think that they've been able to get funds to be able to help, so I'll look on the information.
Good, so I think she gave him her car. But yeah, you look for the information too, because there are some stellar reentry programs across the state. And really, if we affiliate them in terms of, with them, to educate people, then we're furthering our goal, because a lot of people don't know that the advisory opinion is now a workable thing. And that's why the league said, hey, we're gonna spend a lot of time to tell people and go through. Because before, we would not even pick up paper. If you gotta wait 20 to 50 years to get an answer, that's crazy.
It's 90 days.
Yeah.
Yes, Cecile, the reason that we're here today is because Wanda Brown wrote the grant. And the people who are on her committee, would you please stand up, because you're the reason that it all got together here, Sue and Bev. And thank you for doing it. Wanda was going to the prison, and she had the PowerPoint presentation that she wanted to give to the inmates. And for some reason, they had a different, the person in charge of the warden. They got a different warden, and they just got cut off. They wouldn't let them come in. So she's been banging her head against the wall, trying to get this information to the people who are in prison right now. Wanda is over in Wisconsin, riding her bicycle probably across the state right now, but she's done a lot to work on this.
Yeah, a lot of phone calls. Sorry.
So this is just a small token.
Oh, thank you. Can I open it up?
Please,
Okay.
right ahead. I like that. Always open up a present. You should open it up right away.
Yeah. And everybody's whatever it is.
And if you'd like, I'll read the certificate.
Okay.
It says, certificate of appreciation is awarded to Cecile Scoon for all the work that you have done with the League of Women Voters of Florida over many years, the work you've done for civil rights, diversity, equity, and inclusion, and how you have used your expertise as an attorney to advocate for voting rights. With fond thanks, the League of Women Voters of Citrus County.
Wow.
Let's do it. Like that.
Let me go, Peg.
Then hold it together. You get anything, right? Okay.
Put your smiles ready.
All right. See, don't get too close. It's Carol. This is great. Thank you so much. And then another song. Yeah, I mean, so people don't want to let you go, can you tell?
You're gonna get around. That's one thing about university, listen around. Oh, I have a little notebooks. I use these.
Of course.
I use it. I have one in my bag. I mean, I'll read what it's saying.
It says, and so do the pens, and so does the keychain.
Okay.
May you be proud of the work you do, the person you are, and the difference you make.
Wow.
You're welcome. And we will have our food and we'll have our discussion. And so I'll stop recording now.